He also kept Mr. Coates' name on the recommendation. If you recall, we talked about how that is a violation of how you do things. The front office found out about this surreptitious removal of the recommendation and exploded on Mr. Rich. Mr. Rich will not be able to deny under oath that he was scolded for this behavior and admitted that he did it. The recommendation was then repackaged and resubmitted with Mr. Coates' original recommendation for civil litigation included, and the case was approved. But this is another example of the hostility from the very inception of the US v. Ike Brown case that was pervasive and open. An employee who worked on the case of United States Brown versus Ike Brown worked very hard and very dedicated, and he is a minority. He was relentlessly harassed by voting section staff for his willingness as a minority to work on the case of United States versus Ike Brown. Nobody will be able to deny under oath that this occurred, and Mr. Coates, if he were allowed to comply with his subpoena, would describe the harassment of this employee that resulted in an investigation, an employment investigation of the individuals involved, and I believe, although I'm not sure, a reprimand of the individuals involved. There will be written documents about this incident of racial harassment of an employee, a dedicated department employee who was working on this case. Others assigned to the case were harassed in other ways, such as being badgered and baited about their evangelical religious views or their political beliefs. In these instances, the victimized employee was openly assumed to espouse various political positions hostile to civil rights simply because he worked on this case. In one instance, in the presence of other employees, I had to report to Mr. Coates that such harassment was being directed at me too. There was an aggressive campaign in the media to discredit the case of United States versus Ike Brown, often quoting former voting section attorneys. There was outrage that was pervasive that the laws would be used against the original beneficiaries of the civil rights laws. Some people said, we don't have the resources to do this. We should be spending our money elsewhere. And that was how they would cloak some of these arguments. Another deputy in the section said in the presence of Mr. Coates, quote, I know that Ike Brown is crooked, and everybody knows that, but the resources of the division should not be used in this way, unquote. To deny that there was open hostility in the voting section in regards to the US v. Ike Brown case and towards the staff who brought the case, to me, is the same as denying that we are all sitting here in this room today. There was nothing more plain to me and others working on the case, but we persisted and we won. If you had the time to bring every single person who served in the section before this commission, and if they testified truthfully, little doubt would remain whether or not open hostility exists toward race-neutral and equal enforcement of the voting laws, particularly in the case of United States versus Ike Brown. But it wouldn't even take the whole section. Just let Mr. Coates testify.
Could I ask you, was there ever a rationale given to you that you heard that explained what the opposition to race-neutral enforcement of the law was?
There's many rationales, and I discussed this in my pajamas media piece. There's a couple. Let me just highlight one I didn't get to yet. I had a visit once from an attorney who said, you know what, there's never been official discrimination against white people in Mississippi, which is, of course, true. There's no question about that. But that doesn't mean you don't enforce the law equally. And I was told that it's essentially what's called Senate Factor 1. Voting attorneys will recognize the argument that in the absence of official discrimination, you shouldn't be pursuing these cases. And of course, this is incredibly offensive to me. And I just persisted. But you know, they have their arguments, and that's how it goes.
Are there any other items on your list?
Yes, there are. On the day that the Black Panther case, the day after the election, it would be November 5th, 2008, I heard discussions in the hallways throughout the voting section, or actually in the housing section. I'm on the far frontier. The housing and voting, believe it or not, are together on the same floor. I'm on the edge, though. And I could hear discussions about what a joke it was. I heard things such as, no big deal, the Black Panthers. Or it was a media-generated event, which Of course, if you remember back to the 60s, that's what the old segs used to say whenever the New York Times was in town. This was just the media that was causing all this trouble. Fox News. The irony is, of course, that housing is where Rosenbaum was. These were his employees. And, you know, I had visits saying there's lots of issues with that case. I reported all of these comments to Mr. Coates and to Robert Popper. And if they were allowed to testify, they once again would tell the truth about what was happening inside the section. I was shocked that there was skepticism about the Black Panther case, and it deeply troubled the people on the team. So what we did in an effort to let our colleagues know about how bad these guys were was something that this commission did. We got the National Geographic video where the Black Panthers are calling for the murder of white babies in their cribs, which I understand you showed here, and calling for the murders of white people to show the section. We thought, my goodness gracious, fair-minded people will soften their hearts after they see these things. I was not there the day the video played, but I'm told it did not exactly attract a large crowd.
Could I interrupt just to let the record reflect that the individual on the new Black Panther tape who was urging African Americans to kill white babies was one of the defendants?
King Samir Shabazz.
That's correct. He was the defendant urging, and Jerry Jackson was right there with him at this particular event when he said it. It became perfectly clear to me that not only was there open hostility toward equal enforcement in a colorblind way of the voting rights laws, but instructions were given in this regard. I was told by voting section management that cases are not going to be brought against black defendants on the benefit of white victims, that if somebody wanted to bring these cases, it was up to the U.S. Attorney, but the Civil Rights Division wasn't going to be bringing it. If Mr. Coates were allowed to testify and tell the truth, then you would hear that these instructions were given.
All right. That is extremely important, these instructions. Were you there when they were given?
I was present at one instance when this statement was made, and Mr. Coates gave me a recollection of a second time that instructions were given in a management situation.
Okay, the first time, when you were present, who made the statement?
Okay, two things. The statement was that we were in the business of doing traditional civil rights work, and of course everybody knows what that means, and helping minorities and litigating on their behalf. That statement was made by Julie Fernandez, who's the DAG. The statement that Mr. Coates that was conveyed to me about the U.S. Attorney would have to do these cases because we weren't going to do them was also the same individual, Julie Fernandez, has told to me.
Okay. Any other comments?
That's all.
You mentioned Ms. Fernandez. There's a press report also that in front of the entire voting section, all the career staff, she explicitly told them that this administration would not be enforcing Section 8 of the National Voter Registration Act. Were you there? And did she say that?
I was there for that, and I could tell you more about that.
Would you please and also explain what Section 8 of the NVRA is?
Section Motor Voter, everybody knows Motor Voter, has a number of provisions. One, for example, Section 7 is that welfare offices have to give out voter application forms. That's Section 7. Section 8 is a general obligation to do list maintenance. In other words, no dead people can be on the voter rolls. No duplicates, people who've moved away. They have to be taken off the rolls. Okay? So they kind of work in hand. You want to have everybody registered to vote, but you don't want to have ineligible people registered to vote. So it's a partnership. Section 8 is the ineligible part. And a meeting of the entire voting section was assembled to discuss NVRA 8. This occurred in November of 2009. Deputy Assistant Attorney General Julie Fernandez, when asked about Section 8, said, "We have no interest in enforcing this provision of the law. It has nothing to do with increasing turnout, and we're just not going to do it."